there is a perspective that I want you to have with handbooks. And with an employee handbook, the question is, do we have the minimum requirements within it? Are there things that we don't want in it? And also, what are we really trying to accomplish with the handbook? What is it that we want to do? So I have this same analogy. If you were here this morning, this is the same analogy that I want you to consider when we think about a handbook. What we're looking at a handbook is we have to put the organization in a position where we can defend our decisions. Now, where a handbook most often is utilized is in discipline and unemployment hearings, where we have standards or these expectations, and we're under an obligation, if we want to successfully defend a termination, or in an unemployment hearing, we don't want the individual to receive benefits. We have to demonstrate that we've provided knowledge, that they were accountable for the decision, whatever it was, and that they violated the standard. So there's some strategy behind why we have handbooks. Are you required to have a handbook? In many ways, no, not necessarily. They are always recommended because there are key points that you want to include in a handbook, and we'll cover those today as best we can in the time that we have. All right, so I have 2 slides just to give you an overview of what you should have in a handbook. And again, if you want these slides, send me an email. I'm happy to send you a PDF of the slides so that you have them too. Okay? All right. So each of these points, and there's one more slide that identifies some additional thoughts of things you want. We'll talk about each of these in turn and then give you, again, a little bit of an overview about each one. All right, disclaimer and an acknowledgement. The disclaimer is up front. Basically, it is disclaiming certain things. The acknowledgement is the back end. They're like bookends. One at the front, one at the back, and then the meat's in the middle. The acknowledgement is where the employee says, yep, I've read it, I acknowledge it, I understand it. It's not a contract, but it's an acknowledgement. Hey guys, can you guys step out just outside the door, please? Thanks. So you have the acknowledgement at the back end. And then we'll go through each of these other points, all right? So here, take a shot of this one if you want. These are, depending on the size of your organization, when it comes to the FMLA, you may or may not need that. But everything else, these are recommended policies that you should have in your handbook. All right, so let's start with the disclaimer. The disclaimer, the purpose of the disclaimer is to avoid contracts. You do not want your handbook to be construed as a contract. An employee can take language in your handbook and say, or conclude, or argue, you are contractually obligated to do something because of the language you use in your handbook. So we need to be careful with what we say in a handbook to avoid contractual implications. And we do that first with the disclaimer. So we are disclaiming that this is a contract. We do that with clear and conspicuous language. Now this is in bold and capitalized because that's what courts say is clear and conspicuous. So your disclaimer, the language that you use at the very beginning of the handbook to disclaim the contracts, to identify that this is an at-will relationship, to indicate that there are no contracts, or if we do have a contract, it must be signed by the CEO or the president. You want clear and conspicuous language at the very beginning of the handbook. All right? Then, at the back end, with your acknowledgement, the purpose of the acknowledgement is, again, the back of the bookend, to identify that the employee received it, that they understood the provisions, and that they're accountable and aware of the guidelines and procedures. So the acknowledgement at the back end needs to track the language of the disclaimer. We specifically reiterate that there's no express or implied contracts. We reaffirm that this is an at-will relationship and that no one except the president, perhaps, or the CEO has authority to modify that at-will relationship. You also want to be clear if you have reissued the handbook or you have a habit of doing that every year, that this version supersedes everything else. And finally, that you retain the right to revise, delete, or add provisions to it. So again, the beginning portions of a handbook, you have the disclaimer up front, that's page 1. The last page is the acknowledgement. And those two, the language, dovetail together to again create this expectation that it's an at-will relationship, that there's no contracts involved, that we reserve the right to do certain things, and you're expected to follow these standards. You will be held accountable to these standards. That's the bookends. Now, focusing on what you include in the middle. Okay? There's a lot of handbooks that I've reviewed that have a lot of information that is completely unnecessary. And some of it just develops over time. Often, and I think this is more often than not what happens, there is this knee-jerk reaction to something, and so we write a policy. We throw it in the handbook. There may be a good reason for that, but over time, sometimes those reasons change, or sometimes business practices change, or sometimes the employee who had the issue is no longer with you. So the goal with a handbook is to keep it as simple and as concise, accessible, and easy to read, because you don't want your employees to say, well, yeah, the handbook, it's 150 pages and I didn't read it. And that's a legitimate reason not to read your handbook. So you want to keep them simple. All right. So let's move now to the date of the handbook. The date becomes critical, and I have used this argument more in unemployment hearings, more often in unemployment hearings, where the employee says, well, that wasn't the standard that I was accountable to. And I say, well, let's turn to the handbook. Here's the provision in the handbook that you were terminated for. Let's say it's attendance. And there at the bottom, do you see the date? Yeah, the date is version whatever, March of 2019. And then I say, and here's the acknowledgement. Is that your signature? Yeah, that's my signature. So you're saying you weren't aware of the standard? Nope. But this is your signature that said, I acknowledge that I reviewed and understand these policies. Yep, that's my signature. So you are indeed aware of the handbook standards. And this is March of 2019. That's how you prevail in an unemployment hearing, is you show that they had knowledge and awareness of the standard. So the date becomes important. If you have a handbook that was issued in 1999 but has been changed or modified, well, which version is it that we're using? A court or an administrative law judge will toss out your argument if you can't show that it is what's applicable to the circumstances at issue with the employee. So you need to have the date on every page in the handbook. Right along the footer, just drop it in. Eliminates all of those questions. And then, of course, when you update it, make sure that you update the effective date too. Okay? All right. EEO harassment retaliation. This is the second provision, well, the first provision, but the second thing within your handbook that you should have. So you have the disclaimer up front, your next document, because you want every employee to read this, and so you put it at the very beginning where they're most likely to do that. It is your EEO, your Equal Employment Opportunity Standards, your No Harassment Standards, No Retaliation Standards. We use a sample that is a one big handbook sample. It covers all of these provisions in one policy because we want everyone to see it, we want them to read it, we want it right at the front. So within the purpose of this provision is, of course, to educate, but more importantly, it's to educate employees and then eliminate wrongful behavior. But it also allows you as the employer to grab onto a defense in litigation that you have promptly and thoroughly addressed or corrected illegal behavior in the workplace. The first component of that defense is a policy. In every charge of discrimination, where the employee is alleging I was discriminated against because of my age, my disability, my gender, my skin color, my sexual orientation, one of the questions that the agency investigating the claim will ask is, what is your harassment policy? We want a copy of it. And we want to see that the employee knew of it and acknowledged it. So this is a big deal. All right, what we look for in that policy. First, you want a statement that you are an equal employment opportunity employer, that there are certain protected statuses, age, race, sexual orientation, skin color, all of those protected characteristics. List them, identify them, and state that they are off limits, or the decisions made in our workplace are off limits based on those characteristics. And then you move to harassment. Define what is unlawful harassment. We prohibit this. You also want a section based on sexual harassment that specifically says we prohibit sexual harassment in the workplace. Now, the next one, though, is an accommodation statement. I'll talk in more detail about this in just a minute, but as an overview of what this big policy looks like, this comprehensive document, you want a section that talks about what your accommodation obligations are. Because again, you want to inform your employees of what their rights are. If I have a disability and I need an accommodation, here's what I do. You talk to whoever it is to request an accommodation. Well, we're under an obligation to accommodate in a variety of circumstances, the disability under the ADA, Title VII religious accommodations, but under Utah law we also have to accommodate for pregnancy, breastfeeding, or other related conditions, and for gender identity situations where restroom or dress or clothing becomes an issue based on the gender identity of your employee. So, once we have these major provisions, you then need something to help the employees understand, if I feel I've been treated wrongly, what do I do? Who do I talk to? What does that look like? You need to identify the complaint process within your handbook or within this policy. And then finally, at the very end of this big policy, you want to state that we as an employer do not tolerate retaliation. Retaliation means we attack or get back at you, or colleagues, co-workers attack you or get back at you because you've exercised a protected right under the law. For example, you make a request for an accommodation. And if we terminate you because you've made the request for an accommodation, that's retaliation. That's illegal. So you want to specify that you don't permit that also. All right, questions on the big policy or any of its components? All right, silence means no.
I'd like to...
Go ahead.
On the effective date?
Yes.
Update something, you have to send an entire copy of that policy to every employee on the re-sign.
Great question. So we have a handbook, and we just updated it 2 months ago, but then something happens, the law changes, or we have this new policy that we want to implement. Do we need to reissue the handbook? Not necessarily. I recommend typically annually, or maybe every other year, but can you issue something, a standalone document that has the same effect as the reissued handbook? Yeah, but you would want an acknowledgement from the employee and language that says this is part of our handbook. You've acknowledged that you've received it, that you understand what you're expected to do or how you're accountable. Sign it that you've acknowledged it, that you've received it. Yeah, that would be a good policy to do, or a good process to have. Great question. But then when you do update your handbook, make sure it's included in there. If again it's a standard, okay, if it's a procedure, like if this happens then you do this, if your job says this then you do that. Policy or procedure like that you don't want in your handbook. You want broad characterizations of standards, no harassment, no retaliation, no workplace violence, show up on time. Those are the big, the required or the expected provisions in a handbook, not this is how you do your job. If this happens, we want you to do this. If that happens, it's not a manual. It's a standard, a collection of standards and guidelines. All right. Okay, so here are the accommodations that you want your policy to address here in Utah. If you have multi-state operations, this list may change. It may get bigger, it may get smaller, it just depends on where you're doing business. You want the disability accommodation language. You want religious accommodation language. Gender identity accommodation in dress and grooming standards and facilities. That's per Utah law. And then also pregnancy, childbirth, breastfeeding accommodations per Utah law also. And these could be just one sentence or two in a paragraph that talks about accommodations. All right. Problem solving. Now, is this technically required? No. Is it recommended strongly? Yes. Why? Why would you want a problem solving paragraph in your handbook?
Documents that you're making an effort to communicate with your employees.
Okay, that's good. Good. It's credibility. Do we actually want our employees to come and tell us when they're upset or they're having a difficulty or something?
Yeah.
This is a way to do it. Now, is this the only thing you should do? No, clearly not. Because again, just because it's written in a paragraph in a handbook doesn't mean that that's an incentive for me to do it. You need to have a culture that's built around this also. And this is the beginning piece, if you will, of creating a culture where your employees feel comfortable and feel like they can come to an organization and say, I've got an issue, I've got a challenge, I've got a struggle. You want that, yes?
I would also think that I would like to include in that when and where it's appropriate for them to come with their concerns. Because we've had some issues where things have come up in situations that could have waited for a more private time. And that, I think that's something we can include in this.
Potentially. I'd like to see how that language looks when you put it together, because in some situations, like wages, for example, talking about the wages. I'm a regular employee, and I'm talking to a coworker and says, yep, we are paid beans here, and I don't like it. Do you want something to limit that? No, you don't, because that's illegal. You can't limit that. So it depends on the context and what you're trying to, or how you're trying to develop that, when it's appropriate. Maybe. So there's some language there that perhaps you would want to finesse, but you're looking at, again, can we do that? Perhaps. Perhaps you could. It would depend on what you're trying to address.
Somebody that complains at everything.
So the frequent complainer?
Yeah.
Okay. I don't think you'd want we don't want the frequent complainer language in your handbook, because that's going to create, at least from my perspective, if I'm the employee who wants to file a claim against your company and you say, well, we've got this policy that says we want to hear you, my response is, unless I frequently complain, then you don't care what I have to say.
It's more like when and where should you present this?
Okay, so I agree with that. Identifying individuals to whom a complaint can be made. That's appropriate.
And in what company? Like of people? The body of who's there?
Maybe I could get there. Maybe. I think we're close, but I just have some questions that I would like to see what the language looks like.
Okay.
But maybe. That's a solid maybe.
Okay. A solid maybe.
It's a solid
I'll
maybe.
take a solid maybe.
So when you're looking at that credible problem solving, what you're trying to do is create a viable, credible internal process to resolve concerns. You want it to actually function and work. Aren't just words on a paper. You want to establish time limits. I think to your point, and when it's appropriate, or the circumstances in which it's appropriate to raise those types of concerns. You could have some oversharing, and could you have language that addresses that? Maybe, but again, there's a little bit of finessing with that, because I'm a little uneasy about that. You also want to allow for me, the regular rank and file employee, to go around my supervisor. Maybe the supervisor's the problem, but if I can only bring the complaint to him, you've just created a barrier to the process. So there needs to be an end around to get around that individual. And finally, identify who the final decision maker is. I don't care who that is. Just identify the buck stops here. The decision ends here. That could be the president, the CEO, whoever that is. It could be a different executive. It could be your HR person. You want someone with authority and credibility, but you don't want, this is not a never-ending process. It needs to end at some point. Okay. All right. FMLA, how many of you have 50 or more employees? All right. This will then only apply to you guys. As an eligible or a covered employer for FMLA, you are required to have FMLA notice language given to your employees. The easiest way to do this is in a handbook. Because again, everyone's going to get the handbook, and this can be just one long policy. It's about 2 pages long, but it covers all of these requirements. So you have to do this as a covered employer. If you don't, that's a violation of federal law. So you want to cover, what are the leave entitlements? Well, I'm not going to read them. Just this is the list of what you need to cover within the policy. Now, the Department of Labor has a sample notice that you can literally just dump in your handbook. Or you can, okay, that works. Okay, that's a whole nother question there. But you can do that. Now, there are some components of how you administer FMLA that go beyond what the minimum requirements are that you will want to add to that policy, such as how do we calculate the 12-month period in which your eligibility is determined? So do we want a look back period? Is it a look forward? Is it a rolling? Is it a calendar year? You need to identify that. Because if you don't, it defaults to whatever works the best for the employee. And that you've lost control in that point. You also want to identify, do we allow the employee to take a paid leave while they're using their FMLA? You can say yes or no. You can allow it or you don't have to. It means I just roll off my vacation or my PTO.
And how does that apply with, say, health insurance benefits? They're off for 12 weeks. We're required to pay their premiums even though they're not the producers as well.
Great question. So as part of the FMLA, the protections for me as someone who goes out on leave are benefit continuation on the same terms and conditions as if I was still working. So let's assume it's an 80-20 percentage. I pay 20, employer pays 80% of the premium. I'm no longer working, I'm on leave, I'm still obligated to pay my 20%, you're still obligated to pay your 80%. While I'm on leave. And then when I come back, you continue to have payroll deductions or however you do it. But when I'm on leave, correct, it's whatever those percentages are. Those continue and you're obligated to maintain those standards. If the individual can't pay their portion or if they don't pay it, let's go there. If they can't pay it, not your problem. If they don't pay it, you still pay your percentage. And then there's a notice process in the FMLA regulations that allows for you to notify the employee, hey, you've missed your premium, you're on notice, you have a 30-day period, I think, to correct that. And if you don't correct it, we will cancel your insurance. And you can do that with notice in that 30-day time frame. And when they come back, you can potentially recoup that from them. So you have some ability there to push back. You just need to set it up correctly. All right, you're welcome. All right, so that's the FMLA. Now the other part though is medical leave. Now medical leave, what we're talking about here is if I have a medical condition, such as a disability, it's recommended, not required, but it's recommended that you have some language in your handbook that talks about what you do with an individual who has a need for medical time off, so that you're consistent and that the standards, the expectations are consistent. Again, you're not required to do that, but it's recommended so that you have a consistent process that supervisors or managers and the employees can be aware of what to do and how to do it. Okay? All right, drugs and alcohol. This is an interesting one, especially with the medical cannabis stuff. What we're trying to accomplish with drugs and alcohol, well, the policy depends on what you're trying to accomplish. You could have a standard in your handbook that says, we are a drug-free workplace, period. We don't test. We just have a no alcohol, no drug standard. So if we see you impaired or intoxicated, if we find illegal substance in your locker or in your truck, then we can take a disciplinary action. And we don't use a drug test to validate what we've done. We're just saying we've observed a violation, the same as if you don't show up on time for work. We've observed a violation and we impose a consequence. Or you could have a testing mechanism which says we test. Now if you do have a policy, or if you do want to test, and this is a critical piece here, you have a simple standard in your handbook that says we have a no drugs, no alcohol standard, and oh, by the way, we have a drug testing policy. See the separate policy. If you do have a drug testing policy, you do not want to include it in your handbook. Including it in your handbook runs the risk of creating the argument that your handbook is a contract, because the specificity and the detail of a drug testing policy reads like a contract. If you do this, we do that. If you test positive, we do this, we do that. You don't want that. Plus, it's a privacy issue. You want a very clean, clear acknowledgement that the employee has agreed to be tested under whatever those circumstances are. And you don't want any privacy issues. You want to make sure that they actually read it. You don't want it in your handbook. So you have a separate standalone testing policy that outlines the what, the when, and the how. All right, now, how you do it in the handbook, well, it again depends on what you're trying to accomplish. Are we zero tolerance? Are we drug-free? Do we test? You design your policy to meet whatever those needs are. Questions on the drugs and alcohol? All right. If you do test, this is what your policy needs to cover. Now, this is an overview. There's a lot more detail that the law actually requires, but this hits the highlights. Utah has a law that says if you, employer, want to drug test, we will statutorily provide you with protections from liability if you follow these requirements. And by following these requirements, if you discipline or terminate the employee, we will waive liability, if you will. We won't give a claim of liability back against you because you followed the statute. So first, you have to have it written. It needs to be distributed to employees and available to prospective employees. You also are testing for impairment under these circumstances. Post-accident, now the word impairment, that comes out of the statute, which is interesting in the context of the medicinal cannabis. Because do we really have impairment? I don't know. So there's some questions of conflict between the medical cannabis law and the drug testing statute that no one seems to resolve or be aware of. Post-accident, maintenance of safety or maintenance of productivity, quality, or security, those are the reasons you can test. You identify those reasons in your drug testing policy. When the testing occurs, it must be during or immediately after the regular work period. And how the testing process goes, the confidentiality, the privacy, chain of custody of the sample, you want to make sure that those are all rigidly adhered to. It's almost a promise, if you will, and a guarantee to the employee that we will do those things. And then finally, you pay for the testing costs. It's on you. You also pay wages for your non-exempt employees for the time that they spend being tested.
Okay, I have a question.
Yes.
So if an employee fails and then they need to be retested, can we require them to pay for the retest?
If you want the benefit of the statute, the cost of the test is on you.
Okay.
If you don't want the benefit of the freedom from liability, then have your employee pay for it. I don't think that's the best approach. And there are other reasons why I wouldn't do that too.
Okay.
I think you want the liability protections, but again, you require that I be tested. Should I really bear that burden? I don't think so. I think it should be the employer who does it, who covers that cost. And specifically, if you want the liability protection, it's on your dime.
It's on us.
Yep,
Okay.
it's on your dime. All right, any other questions on that? All right, we're burning through this. You guys are very, very quiet. You're just numb, probably. You've had your fill of HR today. All right, so if you do have a positive test, this is what the statute says you can do. Discipline, suspend, terminate, refuse to hire. You can even rehabilitate if you want. All right. Weapons in the workplace. This one's interesting. As a owner of private property, or as the lease holder of a property interest, you have the ability to preclude firearms on your property. But there are certain ways in which you have to go about doing it, because Utah has a law which says I have the right to have a firearm. I have the right to have it with me, but there are certain circumstances when you as the employer can prohibit that. So here's what it looks like. So if I have a firearm and you permit it on your property, you can require that the firearm be stored in the vehicle, not in plain view, and it's in a locked container or the vehicle is locked. Okay? So you have an individual and the employee brings the handgun, the rifle, whatever it is, on your property. You can require that it is kept in the vehicle, out of sight, that the vehicle is locked, or that the gun is kept in a container that is locked. That's option 1. Option 2, and you have to spell both of these out in your policy, option 2 is we don't permit the firearm on our property. And if that's the position we take, then we have to have storage in a vehicle at some other alternative location or somewhere, typically on site, where the gun can be secured and monitored in a storage location. So your policy needs to actually say these things regarding firearms. Questions on that one? All right. You look very ponderative with that.
Well, I just like, so our guys do new construction and they're driving my truck to a job site. That's my property, they're driving my truck.
You can preclude them from having it in your company vehicle. And the reason, and so go back to the policy, you can't have it in my truck, my company truck. You can keep it on my property, our company property, but it has to be locked in your vehicle. You can't take it into my company truck or on our company property in the office, for example. You have to keep it in your car, locked, out of sight, and in a locked container or the locked vehicle.
But if they're on the job site,
You can preclude them from having it in your vehicle.
but if they drive, like if they're, I'm trying to think of how that would work. Like if he drove his personal vehicle to a job site, which I don't think that would happen. But like he wanted to wear, like we had a guy,
Who has the concealed carry?
yeah, on a job site.
Okay. You could preclude that. You could say, we don't, because you're on a job site, because you're on an extension of work,
Right.
we don't want you to have it. The gun needs to be kept or stored in your vehicle, out of sight, locked, or in a locked container. Good on that one?
Yep.
All right, good clarification. See, I knew you had a question. You had that puzzled look on your face. All right, this is a big one. Most employers don't know this, they miss it, and this is low-hanging fruit. As exempt employees, an exempt employee again is someone who is not paid for the time that they work. I'm paid for the tasks I accomplish. And I'm paid a salary on a weekly basis because of those tasks that I perform. So example, as an attorney, I am an exempt employee. I make at least $455 a week. I could work 5 hours a week, or I could work 50 hours a week, or I could work 100 hours a week. I get the same amount of money every week. It's a salary, it's a fixed amount. Now, if I as the employer make a mistake with my salary, this language in your handbook gives you the ability to have what we call a safe harbor defense. It's an oops, we didn't mean it. We had a policy that says we corrected it, or we take action to correct it. So we're trying to limit liability for failure to properly pay an exempt employee. Here's what it looks like. You have to clearly communicate that we, as the employer, prohibit improper deductions from the pay of an exempt employee. Then you have a complaint mechanism that says if we did make a mistake, you, employee, have the ability to tell us, and we will then correct it if indeed we did make the mistake. We make a good faith effort to comply with that in the future. And if we did fail to or wrongfully deducted your pay, we will fix it. We will reimburse you. If you have that language, this meets the safe harbor defense under the Fair Labor Standards Act, which limits your liability and loss of the exemption for that particular employee. Meaning we don't have to then figure out overtime and minimum wage obligations. We can preserve their exempt status. And you want to do that with your exempt employees. Bet you don't have that one in there, do you? Most companies don't. This is one when we do, as part of our membership, we do an annual review of a handbook every year for a company. And this is one we always catch. It's just most people, yep, they just don't know about it.
And same with the private problem-solving thing.
Yep. All right. Hours of work week. Now, think about, you have your exempt employees and you have non-exempt. Non-exempt are the hourly employees who work based on an hourly rate and are paid an overtime amount when they work 40 hours or more. You want language in your handbook that defines what your work week is so that you know what the calculation of overtime is. In a work week, you have 168 hours. That's simply 7 times 24. Okay? That work week period, you can define that. You can say it starts Sunday at 12:01 a.m. and ends Saturday at midnight. That's a 168-hour period. Or you can say it's a Tuesday to a Tuesday or a Wednesday to a Wednesday. Whatever that is, you can define that. But the key is define it and then make sure that your pay practices for the calculation of overtime run according to that. You are not required to have an overtime calculation that runs Monday through Sunday. Typically, most employees just think that because that's what the work week looks like. when I'm scheduled to work, but it doesn't have to be. You can define that. So we ask that in your handbook you define what that work week period is, because if any hours within that work week, let's say Monday or Sunday 12:01 to Saturday at midnight, within that 168-hour period, any hours worked over 40 become overtime, and you're obligated to pay overtime for that. So you can define that work week period in a way that perhaps allows you to better manage overtime obligations. You can't use it to avoid paying overtime, but it may make sense to limit or manage better your overtime obligations based on the work that you have them doing. All right, also, hours of work. This is simply, what does your regular work day look like? We recommend that employers include that. So our work day starts at 6:30, 7:30, 8 o'clock, whatever it is, and ends at. Now that's a general statement. It's always obviously not going to apply to everyone, because emergencies in your line of business may bring me out at midnight, and that's okay. But we just again recommend that you have this basic language in there to account for what is the regular work day and what is the work week for purposes of calculating overtime. All right, paydays. This is state law. You want to include this in your handbook. So we're trying to comply and notify the employees at the time of hire when they'll be paid and where. If that's a check, if it's direct deposit, whatever that is, you want to define that. And you also want to define when are those paydays. The law requires that it's at least twice per month on days designated in advance, and within 10 days after the close of the pay period. Now, pay periods are not necessarily work weeks. You have a 168-hour work week, which could be 2 pay periods. So your overtime has to be within those work weeks, but you can have multiple work weeks within a pay period. But you just need to define that. So state when it is, and then consistently follow it. And here's a good example. We pay every other Friday. If the regular payday occurs on a holiday, then this is what happens. This is what you can expect. Questions on that one? Okay, is this helpful at all? Okay. I always have a hard time telling when it's silence, and it makes me anxious. Is this just me, or is just the good information? All right, here are some examples of things you do not want in your handbook. Now, there's a lot more that when we look at a handbook and our attorneys and our HR staff are reviewing a handbook, we gut sometimes a lot out of a handbook because you just don't need a lot in your handbook. But for example, vision mission statements. Those are the nice flowery things that talk about why we do what we do and who we are. Do you need to include that in your handbook? No, they should be on your wall somewhere. Can you circulate them outside of the handbook? Yes. The concern we have in putting it in the handbook is often the language that you use in that vision and mission statement could be contractual, could be promising. And when you don't do it, you've created an expectation that the employees rely upon and now potentially have some contractual issues there. So it's an overpromise issue. Don't set the standards and expectations too high in your handbook with lots of flowery language and expectations and promises. Long company histories. No one reads it. No one cares. I mean, we do, but we don't. Now, one of the challenges strategically, if you include the long stuff in your handbook, I may not even make it past the history and get to the stuff you really care I want to read, that you want me to read. So eliminate stuff the hurdles. Keep them out of your handbook. Forms. You shouldn't have forms in a handbook. Forms are where your HR department or a supervisor or a manager, they should be the point of distribution for forms, not your handbook. Because anytime the form changes and I'm using the one in the handbook, is that the right one? Is that the wrong one? I don't know. Clarity and consistency. Standalone policies. For example, the drug testing. Again, recommended keep it out. We talked a little bit about your example. We amend something or we implement something. That could be a standalone policy. But again, the goal is we will eventually move it into the handbook the next time we amend it or revise it, which maybe is the next year. We have it outside for a little bit, but you don't want it permanently. The reason for that is, how do I know where everything's at? How do I know what's all out there? I may have never seen that policy, and yet I'm being held accountable for something that I never saw because it's not in the handbook. It's just out there. It makes sense to have a conglomerate book of policies. Code of ethics, those are nearly impossible to enforce. What is ethical will be circumstantial. You can have broad statements about honesty, integrity, things like that, attendance. But what is ethical? Those are tough to capture in language. And so companies can get in trouble and get sideways on when they try and include that. Agreements, obviously if the handbook's not a contract, we don't want an agreement in the handbook. Agreements like an employment agreement, a payroll deduction authorization agreement, you want those outside and separate. Because again, the handbook is an at-will relationship, and we don't want to do or say things that will limit or impair the at-will relationship with our employees. Questions on any of those? All right. I mentioned earlier the National Labor Relations Act. Your frontline employees, so everyone below a supervisor. The National Labor Relations Act gives them the ability to say crappy, ugly things about you as an employer, as a business. They can complain about wages, and they can talk with each other about these things. And they can even complain about supervisors and managers. All of those conversations are protected. You cannot prohibit those types of conversations in your handbook nor in practice. Because you can't. Because, well, what if I want to gossip about my wages? And what is gossip? I mean, there's a little bit of shady interpretation of what does that really mean. Well, I interpret that to mean I can't talk about my wages or the terms and conditions of my employment with my coworker. So you've infringed upon my rights under the National Labor Relations Act to talk about protected and concerted activity.
Shouldn't that be retaliation? Like if employees are gossiping about another employee, like if they're complaining about someone getting special accommodations, isn't that retaliation?
Good question, good question. So the National Labor Relations Act protects my ability to talk about terms and conditions of employment and wages. All right? If I'm complaining about a coworker because he or she made a complaint of harassment against me, that's different. And you should be dealing with that under the umbrella of no retaliation. But if I'm complaining about my supervisor because he stiffed me on a bonus or docked my hours because of this, that, or the other, and I share that with my colleagues, even maybe it's on Facebook, doesn't matter, that's protected. So you have to be very, very careful in the policies that you implement in your handbook to not chill or infringe on those protected and concerted activity rights. Now, even if you're not a union employer, this standard still applies. This applies to all. Yeah, no conflict. Say that again.
What if they're spreading inaccurate information about the benefit packages, wages to other people?
So
their own, like exaggerating what they make, or the opposite, or talking about what they think someone else is, and telling people in the company codes, and causing disruption there.
Causing some turmoil. You've identified a good middle of the road. I could go either way on that one. And I wouldn't have something in your handbook because of the risk that language would be interpreted to chill my rights to engage in that protected concerted activity. Could you in practice though counsel those employees for sharing or spreading incorrect information that causes disruption amongst the employees in terms of, well, we're too busy chatting about who's getting what and the work's not happening? That's a problem. Can we deal with that? Absolutely. It's the language or behavior that would chill or impair my rights to have or to engage in protected and concerted behavior. You have to be very careful with that. And the difficulty with the National Labor Relations Act is the pendulum goes like this depending on which president or the Congress is in office. Right now we're moving a little back towards what I would characterize as sanity and practical policies, and that's not because I'm Republican or Democrat. It's just the pendulum just continues to swing back and forth. Under President Obama, we had some very, very protective, employee-favored requirements under the National Labor Relations Act that were interpreted as enforcing this. And now it's moving back this way. So it just depends on the administration too. But just overall, be careful not to create policy or behaviors that impair those protected rights. So you need legal counsel to look at stuff like the no gossiping policy. You definitely want an employment lawyer to look at that, because you may have language that chills their rights, and that could be a charge against the organization. Even though you're not a union organization, that could be an unfair labor practice under the National Labor Relations Act.
And then how does that not encroach on like slander or harassment if they're saying things that's hurtful to another employee?
That's different. So I'm not talking now about the terms and conditions of my employment and my wages. I'm now verbally attacking or harassing an individual based on a protected class. Correct. So if you have, and this is where, so think about it this way, I guess. You have two big bubbles, the NLRA stuff and the no harassment, no discrimination, no retaliation. You have to enforce both of those, and there may be a very, very narrow sliver where they perhaps overlap, but rare will be that occasion. If it's harassment, deal with it. If it's wages and terms and conditions and benefits of the employment relationship, probably can't do much about that. But if now it's slander or derogatory comments about characteristics of others or someone who complained, you are well within your rights to deal with that. And that's squarely under your no harassment, no retaliation, no discrimination standards. And the law will and courts will support an employer in that effort, because you're required to. There's no questions about that. All right. Final just recommendations. Your handbook is a living document. If you draft it and put it on a shelf and it sits there, you're doing it wrong. It's something that requires consistent attention and adjustment. The laws change, best practices change, your policies may change. Your handbook should reflect that. Again, we recommend an annual at least update, because like this year, there are some new laws that will affect what an employer can or cannot do, and you want to make sure that that's reflected in your handbook. We also recommend, and this is just best practice, have a legal and an HR person review it. It's a service that we provide as part of our membership, but you can get any law firm, any consultant, they will do this too. And you want that annual review. Communicate the policy or the handbook. Make sure that your employees know where to get it, how to get it, when to get it, why to get it, refer to it, make it part of your trainings, incorporate it into, and make it a living document that you live in the working relationship with.
So should they get a new handbook every year when it's
Physically distributed? Not necessarily.
Okay.
You could make an online version available, and that can have the same effect.
Okay.
But do you need to print one every year? You could choose to do that. You don't have to.
Okay.
You just need to make sure that they have it available and accessible.
Okay.
And it's not kept in the HR person's office, who is ironically never there, and the door is locked, so I can't ever get to it. I think it's wise for your managers and supervisors to have a printed copy, just in case they have a question, they're not sure. Hey, I can look it up. Here it is. Here's what it says. Or, hey, we need some more clarification. Just make it simple. Make it easy for the employees to access it.
Okay.
All right, finally, anytime you issue an update, make sure you get a new acknowledgement, because if you don't have the acknowledgement of the update, then your ability to hold the employee accountable, say in an unemployment hearing, for example, is pretty much gone, because I didn't know, and you can't show that I knew. You can't show that the acknowledgement was there, so just make sure you have that. Simple step to make sure. It's a little bit of an administrative burden, but it's worth its weight, especially if you're challenging unemployment hearings or if you have administrative claims, wage and hour, or charges of discrimination. It makes sense to have that.
Signature only.
Signature only, and it is not.
Replied in an email saying, hey, I acknowledge this.
You could do it that way, and that's, I'm not bothered by that at all, because it says, I, the employee, I received it and I acknowledged it. And I just hit reply in the email, and now you have that. That's an electronic transaction, which would do the same thing as a written transaction. Be careful in your acknowledgement, though. This is not a contract, so you don't want language that says, I agree to abide by, or I will comply with. It's an acknowledgement that I have received it and reviewed it, not that I am contractually obligated to do it. I review and I understand, or I've acknowledged it and I received it and acknowledge it. That's it. That's all you need. All right. It is. With a mobile workforce, that can be tough. All right. Well, you've endured a day of 3.5 hours of HR. Yes. Arms up. It's 5 o'clock. We're done. Any questions for me? I was just joking about 5. If you have questions, I'm happy to stay. I'm serious.
Thank you.
Okay. All right. That's my social media platform. You have my email on the first slide. If you want any of the slides today, just send me an email, and I will happily send them to you. Thanks for coming. Well, maybe we'll see you tomorrow.